All right. Good afternoon, everyone. Happy Thursday. My name is Jorge Acosta Palmer, and I am the director of the statewide training initiative. Thank you for joining us here today to learn about fighting foreclosure, defending VA and FHA homeowners with confidence. Before I introduce our speaker, I want to go through some quick housekeeping announcements. First, this training is being recorded. You're going to receive a copy of the recording in an email from Zoom within 24 hours. If you don't see that email, I'm going to drop my email on the chat just in case. Feel free to reach out to me if you need anything. CLE, as far as CLEs go, this training has been approved by the Florida Bar for CLE credits. I will announce the CLE code towards the end of the session. I will also drop it on the chat, and it will also be included in the email from Zoom in the recording. This particular training has been approved for one CLE general credit and one CLE certification credit for real estate. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. This training is being co-hosted by PILS, which is the Public Interest Law section. If you're not familiar with PILS, I encourage you to visit their website and take a peek. I'll drop the link to their website on the chat as well. Membership is only $35 a year. I have to say it is a pretty cool section. There's a lot of benefits from joining. They have a lot of operating committees and they have a lot of subject matter work groups, such as the consumer and tenant rights work group. I'm a member of that work group and it's great. So I highly encourage you to take a peek and join. And Q&A. If you have any questions, make sure to use the Q&A feature. We will try to address all the questions towards the end. There's a lot of materials that we're going to be discussing today, so hopefully we can address all the questions towards the end. And without further ado, I'd like to introduce our great speaker today, Mike Wasylik. Mike Wasylik is a founding member of Ricardo and Wasylik PL. He was raised in Tampa, Florida. Mike graduated from Northwestern University in 1992 and the Florida State University College of Law in 95. Mike's professional experience included legislative work for the United States Congress, both for the House and Senate, and as a litigator with some of the top law firms in Florida, Washington, D.C., and Virginia. Mike's practice focuses on a wide range of litigation matters, including commercial and business litigation, homeowners' rights, foreclosure defense, and mortgage fraud, consumer rights, and abusive debt collection litigation. Mike is dedicated to helping individuals defend themselves against attack from massive institutions and the legions of attorneys that represent them. Mike is a frequent teacher and speaker. He regularly holds seminars for real estate and legal professionals, has taught several CLE courses on how to defend foreclosure, and is frequently interviewed on radio and television. One final plug for Mike. If you haven't seen his firm's YouTube page, you might want to take a look at it. It has amazing content. So, with all of that said, Mike, uh, it's up to you now. Handing it off.
All right. Thank you very much, Jorge. Appreciate it. So this is pretty exciting stuff. If you've been in the foreclosure space at all, you know how the law has changed in the last several years. And one of the few areas where it's still, where there's still kind of hooks for us to hang our hat on is the space where there's VA or FHA regulations. The VA cases are some of my favorite cases because defending those that defend us is a privilege. And in that particular case, it's nice to walk into the courtroom with a little bit different presumption than, hey, your client's a deadbeat. The respect veterans get is a little bit higher than the average foreclosure defendant. So it's always a privilege to be able to represent them. And of course, FHA homeowners are the recipient of various benefits as well. So there's kind of a presumption that they should be extra protected too. So that helps offset some of the negative associations that some folks have with foreclosures. So Jorge has already described who I am. I want to just kind of highlight the fact that I've basically been litigating for almost 28 years. And I looked it up this morning, and my very first foreclosure case was January of 2006. So I was about 2 years ahead of the big wave. You know, I know that a lot of folks in the room know that Jacksonville Area Legal Aid helped train armies of lawyers to do foreclosures, and we were on the early end of that. So I have handled hundreds of foreclosure trials, saved, I think I added it up at one point, and you know, well over $10 million worth of foreclosure loans that went to trial where we won. So we've helped a lot of people get a lot of relief. Um, I know that a lot of the audience, you're going to be in public service, one of the legal aid associations. Some of you will be private. Some of you are non-lawyers. Some of you are housing counselors. And so it's important for you to know what the lawyers are doing on this, on these cases while you are uh, assisting with the loss mitigation track. So that's hopefully something you're going to take away from today. Um, what do you need to know? So today's focus is going to be on litigating foreclosure cases that are specifically involving these government programs. It's not going to be a fundamentals course of foreclosure defense. We will talk about some of those fundamentals as they specifically apply to this particular area, but this should be considered a supplement to any other foreclosure defense training you might have done. So if you're not already familiar with the field of foreclosure defense, and if this is your first entry into it, then you're going to want to make sure that you bone up on kind of the standard foreclosure defense track before you try to apply any of this. But this is obviously an area that is very exciting if you are in the foreclosure field, because it's one of the areas where we still have something that we can really use to make a great impact for our clients and for justice. What are VA FHA loans? So VA loans are primarily benefits for veterans, where the VA has, as kind of an additional benefit to those who have served our country, we make it easier for them to get home loans, and so help our veterans resettle uh, in a safe, secure home. FHA loans are government-backed loans that are primarily part of the policy, the government encouraging homeownership generally, especially for first-time homeowners and those who might not have already, or those who might not have an easy time finding a standard foreclosure or standard mortgage loan. FHA benefits can often make it possible for people to own a home they wouldn't otherwise be able to afford based on that FHA backing. So these are all government-backed loans. They're guaranteed by the federal government, and the private lenders that engage in them, that service them, are benefiting from that federal backing. And so as a consequence, they have certain obligations that they need to fulfill, and we're going to talk about those today. The special bonus that's mentioned on the screen. I'm also going to mention another government program. It very rarely comes up, but in some rural areas of Florida, you might find this. You're going to find loans backed by the USDA. And there are similar regulatory schemes that are in place for those loans as well. I think I've seen one in my career. Since 2006, I think I've seen one USDA loan, and I wasn't the primary attorney on that. So I'm not going to go into great detail about that, but I will mention it a couple times here and there. So you'll get that added bonus in this presentation. The primary benefit that your clients will get from having a VA loan or an FHA loan or a USDA loan is that that government backing comes with strings attached for the lenders, for the servicers. And those strings are in the form of conditions precedent. Conditions precedent are a conditional, they're a contractual provision that says that before a foreclosure can begin, the lender must do certain things designed to avoid foreclosure, designed to avoid default, and to bring borrowers back into good standing. And there's two reasons for that. One is it's a benefit for the borrower, right? So if you've got a veteran who's struggling, the idea is they want to try and make it easier for that veteran to get on track. Same with FHA borrowers, because they're first-time homeowners or oftentimes less well-off homeowners. The idea is we want to promote that home ownership by making sure they stay in that home. So it benefits the borrowers, but it also benefits the federal government because it protects the federal government from having to pay off on guarantees that aren't where they don't have to, where the foreclosure or where the loss is avoidable. So it's there's benefits on both sides, and the lender, the servicer, is kind of caught in the middle, and they have obligations to both sides to make sure that they do everything they can in order to prevent these foreclosures, these default scenarios, and to mitigate them when they do come about. How can you tell when you have a VA FHA loan? How can you tell when these regulations apply? We're going to talk at some great length about that. And specifically, we're going to talk about how the regulations are brought into the loan context and what actually needs to happen in order for a loan servicer to initiate, prosecute a foreclosure. What has to happen beforehand, what has to happen during, and then a little bit about what the loss mitigation track is going to look like. So, especially for you housing counselors in the audience, that's going to be important for you. Um, every loan is going to have different regulations. VA loans have specific sets of regulations. FHA loans will have specific sets of regulations. The USDA has specific sets of regulations. In addition to those regulations, there are servicer requirements and guidelines, circulars, advisories, urgings, encouragements from the various federal agencies that are involved. So, we're dealing with regulations from the VA itself. We're dealing with HUD regulations for FHA loans, and then USDA, we'll talk a little bit about the USDA regulations. So how do you know if your loan is a VA loan or an FHA loan? Going to the next slide, before you even look at the note, the first thing you want to do is ask your client. Your client will usually know if they got a VA loan, if they got a USDA loan, if they got an FHA loan. They'll usually know. But anyone who's practiced law for any great deal of time also knows just because your client tells you something is true doesn't necessarily mean it is. They may be incorrect, they may be wishfully thinking, or they may be outright deceiving you in rare instances. So you want to go ahead and verify it. And so the best place to look is going to be the loan documents. So on the screen now, I've got an example of a snippet from a VA loan. And usually it's not subtle. I mean, this is a pretty big red flag here. When you see something that says this loan is not assumable without the approval of the Department of Veterans Affairs, that's your first clue that you might be dealing with a VA loan. There are other terms in the note and mortgage that are going to indicate that there's involvement of the VA, and for VA loans and FHA loans, you're going to see loans that expressly incorporate those regulations, and we'll see some of those in just a minute. On a note, you're going to see an FHA case number. The one here is blacked out. They're usually blacked out when they're filed, but the box there you'll see is an indication the loan at least originated as an FHA loan. And so that's going to be your first clue. And then you want to go digging into the note itself. Here's an example from the FHA note. This is in paragraph 6B, and you'll see the highlighted section where it talks about default. And then the red underlined sections, that's language that expressly incorporates the regulations of the secretary. And I want you to see how that contract pulls in and makes those regulations a condition of the contract, part of the promises that were exchanged at the loan closing table. It says here that the lender may, except as limited by regulations of the secretary, do these things, right? So and then it goes on to say that in many circumstances, regulations issued by the secretary will limit lenders' rights. This is regulatory rewriting of the contract, but it's authorized by the contract itself. Basically, it says anything in this note that conflicts with the terms and regulations of the secretary, we're going to go ahead and modify that. We're going to go ahead and make that secondary to the regulations themselves. And then it goes on to say this note does not authorize acceleration when not permitted by HUD regulations. And if you've been doing foreclosure at all, you know that acceleration of the loan, because it's an installment contract, you can't foreclose. Well, you can, but you're generally not going to foreclose without acceleration of the entire loan into the case where you're dealing with it. So if they can't accelerate without doing what the HUD regulations require, they're not going to be foreclosing, and you're going to be able to stop that foreclosure if you can prove that, or if they fail to prove they've complied in court. Here's an example from the mortgage document. So we looked at the notes. Now we're looking at the mortgages. You'll see riders like this attached to VA loans. And again, it's that language that says that the loan is not assumable. And then the rider itself will have some additional language about incorporation of the regulations. Again, you'll see that this not subtle language at the top of the mortgage. This is language that's usually incorporated into the mortgage right above the signature line or on the next to last page. And I want you to take a look at this really carefully, because it says here, it's incorporating the regulations themselves. it's couched as notice to borrower, but it says here that the regulations, et cetera, shall govern the rights, duties, and liabilities of the parties to the loan, and any provision of the loan instruments inconsistent with such regulations are hereby amended and supplemented to conform thereto. So the regulations are altering the terms of the agreement by consent of both the lender and the borrower. So that's something to keep in mind, is that the underlying agreement itself is actually altered by VA regulations. Going to the FHA mortgage, you'll see again that FHA case number. And here again in the mortgage document for the FHA, you'll see it makes regulation, and I believe this is in paragraph 9. I've only got part of it up, but paragraph 9D, it says regulations of the HUD secretary. And I know this is a terribly not legible copy. You'll find better ones, hopefully. Regulations of the HUD secretary. Regulations issued by the secretary will limit lenders' rights. Will limit, not optional. This is not a suggestion. And then it says the security instrument does not authorize acceleration of foreclosure if not permitted by regulations of the secretary. So again, that's very clear mandatory language that says that the secretary's regulations, the FHA regulations that govern these loans, are incorporated and alter the rights of the parties. So they're part of the contractual agreement itself. And that's important when it comes to getting to the courtroom, because the contractual arrangement, the terms of the deal are very, very important when one side is claiming the other side's breached and the other side is claiming that there may have been a prior breach or some other breach that is materially affecting it. Generally speaking, the regulations are found here. You're going to get a copy of these slides, so if you're scribbling these down hastily, don't worry about that. Chapter 38 for the VA, 24 for the FHA, and the USDA is found in chapter 7. So you'll see there. And the regulations for the USDA are fairly slim, but they're equally important if you've got one of those loans. I'm going to go through the regulation itself here. So the important conditions precedent to foreclosure and acceleration. This is the loss. This is the pre-foreclosure default avoidance and mitigation requirement. It's couched as lender as servicing guidelines, servicing requirements, and it's found at 38 CFR 364350 subsection G. And G is very detailed in multiple nesting requirements that you'll want to read it very carefully. This is only the first part. So this talks about that holders shall employ collection techniques which provide flexibility, et cetera, et cetera. And then it says at the end, at a minimum, the holder, meaning the lender, the servicer, at a minimum, the procedures must include the following actions. Number one, we have a telephone requirement. They are required to make efforts to contact the borrowers by phone. Now, if you've followed any of my stuff online or you've heard me talk about this issue, I'm never an advocate for borrowers talking to creditors on the telephone. It's more often than not leads to confusion or misleading conversations that are unenforceable. When you talk about the banking statute of frauds, promises made on phone calls are rarely enforceable. So we're talking about something that I don't think really benefits the borrowers, but the regulations require it. The regulations require the servicer to reach out and try to find out what's going on. And when you read this, it's interesting to read this, what the purpose of this phone call is. It says, when talking with the borrowers, the holder should attempt to determine why payment was not made and emphasize the importance of remitting loan installments as they come due. Now, why? Obviously, the importance of paying when it comes due, that's designed to protect both the borrower and the federal government. Why are they asking why payment was not made? So as we go through the regulations, there's no reason. The only reason seems to be to extract an admission out of the borrower. I've never seen that actually used in court, but it's almost never, it's almost never to the borrower's interest to talk to the lenders on the phone, but they do have to make the attempt and they have to prove they made the attempt. We'll talk about the burden of proof in a little bit. Letter requirement. They have to send a letter. And in fact, they have to send 2 letters. If you read the regs pretty carefully. This is a letter that is due, that has to be sent if payment's not been received within 30 days, and if telephone contact can't be made. And this is the one that says, this is the one that kind of tracks paragraph 22. If you're familiar with Florida foreclosures, paragraph 22 being the notice letter, this is the one that tracks that. This is not as important as the one I'm about to show you in a minute, but just keep in mind that they have to send this letter if payment's not been received within 30 days. So and they couldn't make contact by phone. Let's go to the next slide. So this is the face-to-face requirement. You'll see this in the FHA as well, that if they can't contact the borrower, then they have to send somebody to the property, knock on the door and say, we're from the government, we're here to help. And so some veterans will be a little skeptical of that, but you'll see that they do have to go out there. And then here's something important to remember. We're going to get into this in the case law. They have to have a face-to-face interview or make a reasonable effort to arrange the meeting. What is a reasonable effort? It's not defined in the regs. But if they send somebody at the property, knock on the door, and nobody answers, then usually that's going to be, that's going to satisfy most judges that the reasonable effort was made. But the reasonableness of the effort is going to be something we'll talk about when we think about substantial compliance, which is not something that's present in the rest of the regs. This is G14, I think it is. Let me see here. Going back, G1 subsection 4. Yeah, the numbering of the regs is not exactly transparent. So the letter from Little Roman 4 is a different letter than the one we saw in Little Roman number 2. And this is a letter to the borrower if payment's not been received within 45 calendar days of us. So this is not the 30-day letter. This is a 45-day letter. And that's if it's within the first 6 months. But then if it's any other default, it's 75 days. So if there's a default 75 days or less, then that's when they have to send this letter. And they have to mail it no later than 7 calendar days after the payment is delinquent for the time period stated. So it's either the 45-day or the 75-day period. And the latest they can mail it then would be the 82nd day, if my math is right. But math is why I went to law school, so don't hold me to that. There are certain things that have to be in this letter. Number one, toll-free phone number that they can call. Again, I'm not a huge advocate of them calling. Email address, that's better, at least it's in writing. You can prove that that happened. The letter has to explain loss mitigation options. What are your options for avoiding foreclosure? 3, emphasize that the intent of servicing is to retain home ownership. We want you to keep your home, right? So here are the loss mitigation options as well. And then this is the kicker. Number 4, this letter must contain the following language. And these 2 paragraphs are set out verbatim in the regs. And the reason they're important is because they talk about the right of the veteran for these benefits and the jeopardy of those benefits if the borrower doesn't make good on the loan. And so it's kind of like that last clear chance for the veteran to protect their benefits that they're getting as a veteran. And, or at least it's a notice of a last clear chance that they need to take this seriously, because if they don't, they're going to lose the right to get VA mortgage benefits in the future. And the fact that it's verbatim is actually mentioned in some of the case law. We'll hit that in a little bit. It is my position that because the regulation spells out the verbatim language, that if there's any material diversion, any material deviation from this language, that they are likely not in compliance. And the reality is that they either send it or they don't. They either have the form or they don't. I've never seen a letter that was almost compliant. They either do it or they don't. So keep an eye out for that letter, and we'll go from there. Moving on to the FHA requirements. Very similar in some ways to the VA requirements. 602, so 24 CFR 203.6. Unlike the VA regs, these are spelled out in different sections of the regs, so they're a little easier to digest. This notice requirement is different from the VA. It doesn't spell out verbatim language, but it does require it to be on a form supplied by the secretary or on a form approved by the secretary. I have never once seen a servicer purport to have a form approved by the secretary or supplied by the secretary. They have no idea what this means. They have no way of tracking this. They have extreme difficulty providing this at trial. I have never once seen that. How does that form that is supplied by or approved by the secretary differ from any other, for example, paragraph 22 letter? I'm actually not sure, because again, I've never seen a servicer tell us this is the form we got approved, or this is the form that the secretary gave us. So your guess is as good as mine, but not once have I ever seen that. And I think this is a material issue because the approval by the secretary is spelled out in the regs, and and it's part of that. It's part of the deal that the lender made, right? It's that they want the secretary has the right to make sure that the borrowers are getting the proper form of notice. And so if they don't comply with that, then they don't really have a right to receive the benefit of the guarantee. Moving on to the next requirement. So we skip over 603, we go to 604. This is the face-to-face requirement. And again, we have language here that talks about making a reasonable attempt to make this. This is actually going to come up in one of the cases, this specific provision. But generally speaking, this does not depend on the telephone call. This depends on, there's a couple of different, other programs that are kind of folded in this requirement, but it just says that they must have a face-to-face meeting with the mortgagor or make a reasonable attempt. So again, if they send somebody to the property, knock on the door, nobody answers, that usually is going to satisfy them. But there's almost, but it's very difficult for them to prove that in many cases. And so we'll go to the next slide. 604, exceptions to face-to-face. They don't have to do it if the mortgagor doesn't live there. So it's an investment property somehow, right? If you get a duplex, they only have to knock on the one that the borrower lives at. The mortgage property is not within 200 miles of the mortgagee, servicer, or branch office of either. There are cases where that becomes a factual issue. So you need to know where your servicer is located at the time of the purported face-to-face meeting requirement. When that kicks in, you need to know whether they're there. So the bigger the servicer, if it's a big bank like Chase or something like that, then you're good. Most of these loans now, or many of these loans, are not serviced by big servicers like that. So you might have to do some math, get on Google Maps and figure out how far away. If the mortgage or the borrower is clearly indicated that they will not cooperate in the interview, don't bother calling me. I'm not going to talk to you. That's usually going to be a factual issue there. They would have to document that. They've already got a repayment plan, so it's not necessary. Or if a reasonable effort to arrange a meeting is unsuccessful. So again, this is the reasonable effort requirement. Now, this is a definition of reasonable effort. So at a minimum of one letter sent to the mortgagor certified by the Postal Service as having been dispatched. So it's not just knocking on the door. That's the next part. But they also have to send a letter, and it has to be certified by the Postal Service. Again, I've never seen them do that. So if they do one but not the other, have they made a reasonable effort? Well, this sets the minimum standard. So I would argue it would not. The face-to-face meeting requirement, again, here's another carve out for the 200 miles, or if they're not residing there. So it would, the restrictions here seem to be that they don't need to make the physical trip to visit the property, but they do still have to they do still have to send the letter, to the best of my reading of that. Again, that's not an issue that's come up. Usually it's all or nothing. They either prove it or they don't. 605 is loss mitigation performance. The reason I bring this up, this talks generally about the duties of the servicer. I've highlighted a couple instances where the mortgagee has a shall duty, shall evaluate on a monthly basis all the loss mitigation techniques to determine. So in other words, so for every borrower, they have to go back and say they shall evaluate on a monthly basis to make sure that they're giving the appropriate relief to the borrower. Next, they say, based on such evaluations, the mortgagee shall take the appropriate loss mitigation action. So what's the appropriate loss mitigation action? Well, it depends on which specific loss mitigation options are available under the other regs. But then here's the other kicker. Documentation must be maintained for the initial and all subsequent evaluations and resulting loss mitigation actions. So you housing counselors out there, team up with the lawyers who are litigating these cases, because if they're not getting you what you need, then you get to do some discovery on what their evaluations are and what their resulting options are, and if they've complied with these regulations to shall take the appropriate loss mitigation action. And then again, it says that the mortgagee, the lender, shall maintain this documentation in the claim review file under the requirements of previous regulations. And that's usually for the benefit of the VA. But if you are litigating this issue and part of your issue is that the loss mitigation options were not properly provided, that documentation might be fairly helpful. Pre-foreclosure review. This is the part of the reg that says the mortgagee may not commence foreclosure because they must ensure that all servicing requirements of this subpart have been met. Now, the subpart talks about servicing for just servicing for guaranteed loans. And again, I've highlighted that prior to initiating any action required by law to foreclose, in other words, before you file suit, the mortgagee shall notify the mortgagor, shall notify the borrower in a format prescribed by the secretary. So this is the second time that they're required to give notice in a format provided by the secretary. So I think that if they mention it twice, it must be important to them. And their failure to comply with that might be something fatal. I'm going to throw this up on the screen just so you see it, that it's here. These are the requirements from the USDA. There is one section here with 6 subsections. I'm sorry, not 6, 8. And so just know that they're there. Again, this under G, that's also says maintain documentation. So that may be a source of discovery if you are looking at litigation. So litigation approaches. So pleading concerns, discovery concerns, and trial concerns. So let's go through these one by one. Pleading, conditions precedent. This is the regulations are incorporated into the loan contract as a contractual condition precedent. So in this case, if the mortgage plaintiff, if the foreclosure plaintiff does not plead generally that they've complied with conditions precedent, they have failed to state a cause of action. You can challenge that at the appropriate time. I usually wait until trial. But if they don't raise it and you don't raise it, then you may not be able to be in a posture. It's a little bit of a gamble. You're relying on the trial court deciding that that failure to state a cause of action is worthy of a denial or a dismissal. Not all judges would go along with that. So you want to make sure that you evaluate the risk of relying on this. But if they do allege it in the complaint, you have a duty to deny it specifically with particularity. Now, some of the cases we'll talk about later talk about how specific you need to be. I'm going to give you some examples of how I plead these, right? So when I plead a VA conditions precedent, the paragraph that they say all conditions precedent have been met, waived, or performed, whatever. The same number paragraph in the answer, I deny it, and I deny it verbosely, right? And I specifically incorporate the regulations here. You'll see the reference to 4350 G1, Little Roman 2, 4, and 3. And I might even revise this. I mean, I might say 1, 2, 3, and 4, right? And I mention here that does not contain the verbatim language required by those regulations. So specifically invoking Little Roman 4. So that's the detail at which I plead this, and you might want to consider that. I also, in my affirmative defenses, I'll usually restate it in some way, or I'll say, plaintiff failed to perform conditions precedent, see answer number, whatever. FHA, very similar. I cite to the regulations. 602. Let's see, the pre-suit notice of assignment. This is an older, I pulled an older boilerplate. That's no longer something I would raise in a foreclosure case. But then you see here, plaintiff has also failed to provide the face-to-face counseling and other foreclosure avoidance opportunities. And then I list 600, 602, 604, 606. So I'm very, very detailed about which regulations I'm citing to. And and while I haven't done a USDA answer, I would do the same for that. I would cite to the specific regulation. Discovery. Do you or do you not do discovery? It depends on what your goal is, and it depends on who your opponent is. Sometimes the lender did these things, they just don't know that they're supposed to prove them. And their lawyers who may or may not be busy, overloaded, or not even understanding that they need to do these may not know what they need to provide. Sometimes they do. Doing discovery may or may not tip them off to this. So if you do discovery, I generally keep it very, very general. Um, Ask for all communications, ask for all records of loss mitigation, ask for things like that. Don't necessarily refer to the regulations if you're trying to not tip them off. If you think you have something where you can affirmatively prove that they didn't do it, um, then go ahead and cite the regulations. But generally speaking, when I'm doing discovery on these, I keep it fairly broad, because what I find is if I don't alert them to the issues in the regulations, they're not going to go digging for them. At least in discovery. If I don't ask them for the specific documents that are required by the regulation, they're not going to go digging for them, because um, they don't really respond to the answer in a meaningful way that doesn't tip them off. But a discovery requests force them to go digging, and they'll find it. Now, on the other hand, if you ask for it and they say we don't have it, then you're in pretty good position. You might even file a summary judgment motion there. But again, beware, because if you file a summary judgment motion, that might force them to go digging. They might even get escalation counsel. It's happened to me once, and I found out that they actually did comply with everything. So that was frustrating. But the good news is that case is well on its way to loss mitigation. And these are so if you need to go to a motion to compel for any reason, this is the regulation you'd cite for each of those types of cases. At trial, what happens when they fail to prove a condition proceeding, or you prove that they didn't? So you can move for involuntary dismissal under the rules. That is increasingly a less favored device. It requires that they have produced zero evidence of at least one of the required elements of proving they complied with all the regulations. So if the plaintiff closes its evidence and they have failed to introduce some evidence as to one of their obligations, you may choose to move for involuntary dismissal. I nowadays have been leaning more and more in favor of asking for judgment in favor of the defendant based on the greater weight of the evidence, because I feel that that's more appellate proof. I've had that issue come up in the appellate courts, and I actually had a case where it was a lost note case, and it was remanded. The involuntary dismissal, which I'd won, was remanded to the trial court for entry of judgment based on the greater weight of the evidence. Fortunately, I won that as well, but it's something to keep an eye out for. I'm going to go through some of the condition proceeding case law here in Florida, specifically as it applies to VA and FHA regulations. Probably the case that's going to be most interesting if you're really super into the minutia of pleading and really want to make sure that you plead something correctly. This case, the Darwin case, is very, very informative. I happen to be a big fan of the appellate lawyer who won this case. If you read the case, you'll know why. But the denial of compliance with FHA regulations put the burden on plaintiff. So we're going back to the pleading stage. The answer, where the answer says you didn't comply with the FHA regulations on this, that then shifts the burden of proof to the plaintiff. They have to prove, as part of their case in chief, that they did all the things required by the regulations. So for FHA, that's the face-to-face counseling. That's the letter on the form approved by the secretary. For VA, it would be the other things. You'll see that the FHA and VA case law is very adjacent to each other, and it really converges a lot. So you'll see that as we go through them. If the and this talks a lot about what was pled and what was not pled as an avoidance. So, for example, if they have a legal excuse for not complying, let's say they say, "Oh, the mortgagor, the borrower said that they didn't want any loss mitigation." I believe they have to plead that. I believe they have to plead prejudice. I think there's some case law that says that. So you want to see if their reply incorporates any of those avoidances, those legal excuses for their noncompliance. And if so, be prepared to meet that. But anything they plead in their reply is also, they have to prove both ends. They have to prove compliance or a legal excuse for noncompliance. And you don't have to prove anything if you've properly denied it. All you have to do is sit back and watch for their failure proof. Dela Cruz, very similar. The denial in the pleadings, the denial in the answer was enough to shift the burden to plaintiff at the trial. So that's something to keep in mind. You'll want to read all these cases too. Burden of proof, Palma basically connects the idea of the FHA regulations and equivocates it to being no different than compliance with paragraph 22 in a standard mortgage. So again, we have where they've pled it and you've denied it, it's their burden of proof, just like if they fail to prove paragraph 22, if they fail to meet their obligations in the regs, and this one again was another FHA case. Koonsman, this is where the reasonableness issue comes in. So Koonsman is couched as a substantial compliance case. If you've done conditions precedent, you know that strict compliance is not the standard for paragraph 22, and substantial compliance is. It's always been my position that the regulations have never been substantial; they've always been strict. But the parts of the regulations that say reasonable efforts are required, reasonableness is required, that's what Koonsman turned on. Even though it was couched as a substantial compliance case, it was really, it was about the face-to-face interview. And again, that couches on the reasonable efforts to make that happen. And in that particular case, the facts were that they did make some attempts. And so they proved the reasonableness of their efforts. And so that was substantial compliance. So that's something to be aware of when you're talking about, did the plaintiff meet its burden of proof? Did the plaintiff meet its burden of performance? Keep in mind that some of those reasonableness requirements are there. But remember, there's also other requirements, say shall and must. So you want to keep in mind those things as well. Wallace v. Nation Star. This is a very recent case. This was an issue where they were trying to prove the face-to-face meeting attempt, and it was a business record that was found by the appellate court to be not admissible because it was provided by a third party. And once they excluded that, there was no evidence that they made the attempt to make the face-to-face meeting and therefore remanded for dismissal. So that's a very recent case here in the second DCA, which is where I practice. And so evidentiary issues can come into play. So if you are doing foreclosure defense, you want to bone up on your evidence. So I've got Koonsman here twice because it's important. So substantial compliance, because this is the part that talks about the reasonable effort to arrange a meeting. So it's, again, that reasonableness requirement. This is the first one that talks about the VA regs in the same light. It's DeLong. And it says that the VA regulations are valid conditions precedents if they're incorporated by the loan documents. And that's going to be the issue that comes up. And that remember when I talked about the verbatim letter, this case talks about that as mandatory. That mandatory language is acknowledged in this opinion. So it's very important, I think, if you're doing a VA case, you want to cite to DeLong if you're arguing that the verbatim language needs to be included and hasn't. This case, again, equivocates it to paragraph 22 by citing to the Samaru and Cologne cases. You'll see the cites for those inside there, but just know it's basically applying the same type of analysis as paragraph 22. This is the one that kind of shook the condition precedent analysis because normally when a contract says borrower must do or lender must do X before foreclosing, in Diaz, the loan documents did not expressly mention FHA regulations, and the borrower said, "Well, I'm asserting it's an FHA loan, so now it's your burden of proof." And the court there said, well, wait a minute, we don't see there's nothing in the loan documents about this being an FHA loan. So if you're going to assert that and it's not clear from the face of the documents, then the burden is on the party asserting the existence of the conditions to establish their applicability. Normally, the burden is going to be met if you see the language that we saw earlier in the loan documents. Normally, that's going to be met, so you don't have to worry about that. This case is kind of an outlier. Hart's is it was undisputed in that case that the loan under review is guaranteed and insured by the Department of Veterans Affairs, but somehow they still failed to prove that the regulations applied. It doesn't talk about the terms of the loan documents, whether it was incorporated in the loan documents. It just said it was guaranteed. So it's unclear that from the facts of this case why this happened. So be prepared to distinguish this if it comes up. Just know that it's out there. It's an outlier, and it seems to be dependent on facts that aren't really disclosed in the opinion itself. So I would lean heavily on DeLong, and then compare it to Diaz if you're looking at that. So I want to talk too about, just very briefly, about cases where the loan was guaranteed at first, but has gone through several hands. You'll see some lenders savvy enough to say, "Oh, wait a minute, now it's the guarantee is terminated, the regulations applicability is terminated." I believe that if the loan documents are clear up front, it's going to be their burden to show that the guarantees no longer apply, or the regulations application is no longer there. Almost always they would have some kind of documentation in their files. That's a case where you might want to do discovery as to the applicability of the regulations. Loss mitigation, and then I'll take some questions. So every one of these programs has detailed loss mitigation requirements, plans, options, waterfalls. Right now we're seeing, what I'm seeing is the VA loans are on a moratorium because the VA decided to roll out the Veteran Affairs Servicing Purchase Program, which basically it's kind of a last resort. If none of the other options in the waterfall work, then the VA would repurchase the loan, modify it with a favorable interest rate so that the borrower can get back on track. They opened that program up in May. Most of the lenders don't even realize that this is already in place, right? So when you see case management conferences where there's been a VA moratorium issue raised, these lawyers for the other side, they just say, "Oh, there's a VA hold." And the judge will say, "Well, what's going on? Has the VA done anything?" And the lawyers will say no, because they don't understand. This program opened up in May. So now you know more than they do, because they don't know that. They don't raise this. The moratorium was just extended through December because the VA is giving the servicers a chance to update their technology to come up to speed on these programs so that they can start offering to the borrowers. You're going to want to check out these two resources here. I've given you chapter 9 of the handbook in the materials. You'll be able to get the access to those after the seminar. And then also take a look at the FAQ, which is linked here below, because it talks about what happens if my servicer isn't ready to offer this yet. And it kind of suggests some remedies for the borrower to go through. But it seems to be that the servicers they have both the burden and kind of the discretion about when and how they apply this, which to me is frustrating, and it's frustrating to courts, and it's frustrating to everybody involved, especially your clients. So just keep in mind that that's there. The FHA handbook. This is a consolidation of all FHA policy regarding mortgage servicing for FHA guaranteed loans. I've got a copy of it in the materials. It's a very large document. You can also download it here. This will override, or at least consolidate, some of the mortgage servicing circulars that you've seen in some of the other or prior. Because this just rolled out a few months ago, I think it was. So, but this is a document you'll want to refer to if you are, especially if you're in loan counseling. You'll want to see what their obligations are. I want to say it's like an 1,800-page document. So at the very beginning, it says, if you're looking for something, Control F is how you search. So that's their solution for how big that document is. But that's going to be a wealth of information for you if you're engaging in loss mitigation. The VA also has loan mortgage circulars in addition to the VAST program, and you can find them there. And then also to the entire VA Servicer Handbook, which is multiple chapters, individual chapters you can download. I've got chapters 8 and 9 included in the materials, because both of them will apply to what you're doing here. So take a look at those. And I am now ready for questions. I'm glad that we were able to finish in time to allow people to ask questions.
All right, Mike. So we do have one question.
Great.
Have you seen anything relating to VA foreclosures where the servicer alleges reasonable efforts to comply with conditions precedent.
So the reasonableness requirement, again, to the extent it's not specified in the regulations, I think is not relevant. And in my experience is that they aren't savvy enough to, they'll argue about prejudice instead. And they either have the evidence they comply or they don't. It's my experience that the servicers that comply generally have the records and generally do comply. And the ones that don't or can't prove that they do it, just they'll have nothing. So it's really an all or nothing thing. And the smart lawyers at trial will try to argue lack of prejudice. I think that needs to be pled as an avoidance, just as a pleading matter. But I've never seen them argue reasonableness as to a VA loan. So
That was the only question that we had in the Q&A. There is still time to post questions. I think, here we go. So we had Jim posted another question in the chat. How do you suggest we bring up the fact that this is a VA loan with additional protections for the bet borrower?
got it. Okay. So Jim, that's a great question. I start off with my answer. The denial of the conditions precedent. And the detailed way I do that should suggest that I am loaded for bear on that issue. In terms of when and how to argue that, usually the entire loan is wrapped in the context of this VA protection. So it comes up throughout the scheduling, especially where there's moratoria in place like there are right now. It comes up throughout the litigation. But at trial, you may want to have your client testify. Yeah, I'm a disabled veteran. I'm a veteran and I availed myself of this program. And I tried and tried and tried to mitigate with them and they didn't do their job. That might be a way to bring that up. Generally speaking, I often will just rely on the formal requirements of the regulations themselves. And I might mention in a closing argument in the context of a motion, the purpose of these is to benefit veterans, is to protect our veterans from, overzealous collateral impingement, is to protect them from, overzealous collection efforts and designed to benefit them because this is a benefit to our veterans especially. So I would just use that language as part of the argument in the closing argument at trial if I was motion to dismiss or arguing for judgment in favor of defendant.
There's a follow-up question from Jim. Do you typically get in the VA regs through requests for admissions or have you called expert witnesses? There's another question in the Q&A, which is about your number, Mike. I just noticed that it's missing one number in the slide. I do
Oh
have
my
it, so I'll
goodness.
post it here on the chat.
Yeah.
But I think the answer for the missing number is 3. I'll drop
Three,
it.
yes.
I'll drop the
The,
full
the very
number in the
last,
chat.
yeah, the very last number is 3. I apologize. If you go to ricardolaw.com, you'll see all our contact information. This is the hazard of having me do my own slides, and I apologize for that. Give me the question again.
Yes, do you
chat?
typically get in the VA regs through requests for admissions or have you called
Oh,
expert witnesses?
got it. So the VA regulations themselves, they're law. I've never had anyone contest the contents of the regulations themselves. I've never had anyone object to their admission. In the worst case scenario, I think they would be a subject to judicial notice. But generally speaking, laws, regulations, case law, you don't need to do that. It's never come up once in any of my cases I've ever litigated. But I wouldn't be surprised if some, if some lawyer who wasn't familiar with the evidence code might try and object to it. So, or if a judge who maybe not be so familiar with the evidence code might grant such a thing. So, good question. Anything else?
Right. I think we may have another one in the Q&A. So we have Mike, from an evidence perspective, how often do you see servicer attorneys try to use FHA connection or similar records to prove FHA compliance or lack of insurance?
So usually when I see that they're attempting to prove compliance, they'll use their internal business records because basically the old joke is a prosecutor could indict a ham sandwich in front of a grand jury. Well, under current Florida law, you could put a ham sandwich in your file cabinet and that's a business record. Um, Understanding the business record exception to the hearsay rule and how to argue it is going to be your best bet on that. But usually, if they've got records like that, I'd want to find out why those are there. Um, if they're not authentic records, if they're not reliable records, if there's indicia of untrustworthiness, then you'll want to rely on those issues. But generally speaking, if they have the records, it's usually going to be an issue where they're going to be able to get those in and prove that they complied.
All right, so I think that's it for the questions. I did drop the CLE information on the chat. I'll drop it again just in case. The CLE code is 2406696N. If you have any colleagues that were not able to attend this training or for some reason didn't register, shoot me an email and I'll make sure that I make these materials accessible to them. I think this is a great training not only for attorneys but for housing counselors to benefit from. So if, as I said, if you have any other colleagues that were not able to attend, I'm happy to share the materials. That email should go out from Zoom in 24 hours, so it will be on YouTube. And Mike, I'm truly grateful for you being here and sharing all of this knowledge. I kind of took my director hat off for an hour here and just turned back into a student. So I always appreciate your trainings. I learned a lot from you, and I'm sure everybody here in the legal aid community also benefits from this. So thank you again. Any final words before we wrap up?
I'm just grateful for the chance to do this, and I hope somebody out there is going to take this information and go save some homes with it. So thanks a lot for being here.
All right, everybody. See you in the next training. Have a great day.